Again, I'm Isaiah Castilla. I am counsel here at Alliance for Justice for our Boulder Advocacy Initiative. And I'm pleased to be with you here today and working with the Disability Rights Network of Pennsylvania. We're especially happy and pleased to work with an organization that is charged with advancing and protecting the civil rights of adults and children with disabilities. I wanted to point out that this training is made possible by a grant from the Pennsylvania, Developmental Disabilities Council through the Disability Advocacy Support Hub, DASH. This is a project of the Disability Rights Network of Pennsylvania. And so we're really thankful and happy for the Pennsylvania Developmental Disabilities Council and for their grant. So this training, again, is about lobbying, and it's a Lobbying 101 training, kind of an introduction, if you will, into lobbying and into the lobbying rules for 501c3 public charities. So first we'll discuss what it means to be a 501c3 organization. It's important, I think, to lay a firm foundation on what a 501c3 organization is. And what C3 can do. Many times you hear people say nonprofits, and there are different types of nonprofits. There are different types of tax-exempt organizations. They have different powers, different duties, different responsibilities, and so we want to kind of lay that firm foundation so that as we move throughout this training, a lot of these concepts will become really familiar to you and really easy, hopefully, to understand. And with that, making these concepts easy to understand, I just want to point out that Boulder Advocacy, what we do is try to help participants. We have web trainings like these. We have all types of resources that we offer on our website, boulderadvocacy.org, and I'll show you that slide at the end of this presentation to help you help us. So, advocacy is a big part of that. What is advocacy? The question always comes up. People always say advocacy, and there's a difference between lobbying and advocacy. They may use those words interchangeably, but lobbying is a form of advocacy, but it's not the only form. It's a very powerful form, and because of its power, because of the access and the power that it holds, the constitutional protections of lobbying, there are some rules attached to it, especially for 501c3 organizations. We can lobby, but to a limited extent, and so we'll talk about the limits on C3s, and then we'll talk about maximizing the lobbying for 501c3 organizations, maximizing what we can and can't do, and being able to do as much advocacy as we can, and being strategic about how we engage in our lobbying activities. As I said, the first thing we want to do is compare nonprofits and start with laying that firm foundation. In this first column, we have 501c3 organizations. And 501c3 is simply the section of the tax code under which these entities are organized. So these are groups like the Alliance for Justice or the NAACP. These are public charities. They are organized for charitable purposes, for religious, scientific, educational, research purposes, and they are tax exempt. And so that's an advantage in their tax treatment. They are tax-exempt nonprofit organizations, but also contributions to these organizations, to public charities, tax-exempt organizations, the contributions are tax-deductible. So that helps a lot for many organizations when it comes to fundraising. We're able to tell donors to point out that your contribution is tax-deductible. That when you itemize on your tax returns, you can get a deduction for your contribution. So that's a huge asset when it comes to fundraising for public charities. In addition to that fundraising advantage, the second advantage comes in the form of private foundation grants. C3, public charities, are the preferred recipient of private foundation grants. So for anyone out there who does a great deal of fundraising or who knows what it's like to do any fundraising, these are some really, really big advantages. I want to point out just briefly that foundations are also a form of C3, but because of how they take their money in, the limited source, they are held to some different standards, some different rules that we won't get into today, but it's just important to note that they are a type of C3. So you'll often hear me say public charity because I'm referring to the most common form of 501c3. C3s are the most common tax-exempt organization. There are over 1.2 million in this country. So, and part of that is because of this tax treatment, the tax-deductible contributions, private foundation grant. But with those advantages, because of our charitable purpose, Congress has seen fit to limit some other advocacy-related or what some people consider political advocacy-related activities. The first limitation is in our lobbying. Sometimes you hear folks say that, or hear people say that C3s can't engage in lobbying. Well, that's not true. C3s, public charities, can engage in a limited amount of lobbying. We'll talk about those limits later. They're actually very generous limits, but there are limits nonetheless. So that's the first limitation. The second is an absolute prohibition on our electoral activity. So we can't engage in a partisan political activity. There are many things that C3s can do, but supporting or opposing candidates for public office is absolutely off the list. So we can't engage in nonpartisan work, that's GTV, get out the vote, or voter registration, candidate forms and the like in a nonpartisan way. We cannot support or oppose candidates for office. Absolute prohibition. The second tax-exempt organization that we want to highlight is 501c4s. You may have heard about these organizations recently, a lot, and they've been in the news quite a bit lately. These are groups like their social welfare organizations, like the Sierra Club, the Human Rights Campaign, the League of Conservation Voters, typically single-issue groups that are charged with improving the general welfare of a community. And so C4s hold a very important place in advocacy. They are also tax exempt, but they don't have, contributions to C4s are not tax deductible. And private foundations, for a number of reasons, C4s are not one of the preferred recipients of private foundation grants. So it may be for some C4s a little bit more difficult to raise money or raise funds for the organization. But C4s can engage in an unlimited amount of lobbying, and typically, most C4s, it's a big part of their agenda and a big part of what they do is to lobby. And they can engage in many of the C3 activities, research, education, and so forth, in all the C3 activities. But they can also support or oppose candidates for public office as a secondary purpose, as a secondary activity. It cannot be their primary purpose, but subject to federal and state election law, they can support or oppose candidates for public office. So it's important to point that out because the C3 can have an affiliated, separate entity. C4, we here at Alliance for Justice have our AFJAC, or Alliance for Justice Action Campaign, completely separate entities. Mission is somewhat similar, but separate entities, separate boards, separate minutes and meetings. But that organization can do a little bit more when it comes to lobbying and perhaps engaging in partisan political activity if necessary. Okay? And so finally, I'll spend some time, just a little bit of time here, talking about political organizations. You may have heard of super PACs or 527s. These organizations are solely charged, and their sole purpose is to support or oppose candidates for public office. They very rarely lobby or engage in any lobbying activity because it can be taxed. It's not their primary purpose. It's not the primary activity that, or exempt activity that a PAC should engage in, but their sole activity is to support or oppose candidates. So when you hear about political action committees, that's what they do. That's what they do. They support candidates and they support partisan political activity. So again, C3 lobbying activity is limited, but we can engage in that activity. So it's important to talk about advocacy. What is advocacy? I want to start here first, right? Lobbying, again, is a form of advocacy. You see it on the screen, it's there in yellow, and the reason why, there's some rules that we have to adhere to. There's some things that, because of the power that lobbying holds, some rules that we have to keep in mind. There's some limits there. But it's not the only form of advocacy. As you see on the screen, we have regulatory efforts, nonpartisan voter education, the lobbying exceptions that we'll get into later, training, research, encouraging voting, litigation, and the like. You know, many avenues for advocacy, and the only arrow in our quiver is not lobbying, but it is a very important form of advocacy that we want to discuss today. Partisan political activity is in red because it's completely off limits for 501c3 organizations. But there are many advocacy avenues. And when we engage in advocacy, when we engage in lobbying, good things can happen, right? Great things can happen. One of those things that happens is, you know, here's an example. So the Lilly Ledbetter Fair Pay Act, for example, which was the first bill signed into law by President Obama when he went into office. And the reason why is, you know, a great deal of advocacy occurred on the part of many organizations. For example, Moms Rising, Alliance for Justice, a number of groups came together to engage in grassroots lobbying and direct lobbying. And as you see on the screen, a whopping 80,557 letters were sent to the U.S. Senate in favor of this legislation. So that's huge, right? And the persistence pays off. So many things can be accomplished, many great things can happen when we engage in lobbying. Here's another example of lobbying, ballot measure advocacy. As we'll talk about later, engaging in ballot measure advocacy is a form of lobbying, according to the IRS. Under the IRS definition, that is lobbying, going directly to the people, asking for an up or down vote on something that will ultimately become, on a measure that will ultimately become binding legislation. So that's considered lobbying. And so here's an example of lobbying done on, and this is an older example, but lobbying done on anti-smoking legislation or ballot measures. Here we have political action and then community organizing. And then a number of national victories that the NAACP had on a lot of different advocacy agendas that they engaged in, whether it was litigation or the Affordable Care Act. You know, advocacy can change policy, and systemically can change, make systemic change when we engage in advocacy. So C3s hold a very special place when it comes to advocacy and changing policy and making change for most Americans. We're also very close to our communities, and so you know, it's very important that we keep these issues in mind and that we work really, really hard to change policy. So, all right, so how much lobbying can we do? So built into the very definition of a C3, of a public charity, is a limit on lobbying, that no substantial part of a C3's overall activity will be to engage in lobbying or engage in legislative propaganda. So that's built into the very definition of a 501c3. So the question is, how much lobbying can we do, right? How much lobbying does the IRS allow 501c3 public charity to engage in? Well, the way that we answer that question is through a test. So, from the very definition of a C3, we take one of our tests, the default test. It's called the insubstantial part test or the no substantial part test. Again, the first measure, or the way that the IRS measures our lobbying activity, is through the default insubstantial part or no substantial part test. Now, the problem with that test is the question comes up, what is insubstantial? Well, the IRS has not necessarily defined what insubstantial is. We know that it is an activities-based test, right? So it's based on an organization or a C3's overall activity. So the IRS looks at a number of activities, whether you're participating in rallies around legislation, ballot measure advocacy. There are a list of activities that are listed on the Form 990, which is the form that that C3s will file to the IRS at the end of the fiscal year. There are a list of activities in Schedule C, that list those activities that we use to measure under the insubstantial part test. And so what you want to do is go to Schedule C, to Part 3 of Schedule C of the Form 990, and look at those activities if you are using the insubstantial part test to measure your lobbying. Okay? Now the penalty for exceeding our lobbying limit under the insubstantial part test, and that limit under the insubstantial part test is somewhere around 5% of our overall activity. So if you're under the insubstantial part test, if you have not made the 501h election, which we'll talk about in a second, you want to keep your lobbying activities under 5% of your overall activity. The penalty, if you exceed that limit, is that you will lose your tax-exempt status, okay? So we want to make sure that we don't do that. But we have a more concrete test, and we encourage organizations to make what's called the 501h election. It's an alternative to the insubstantial part test, and you make this election by filing Form 5768 with the IRS. It's a one-time election. You fill out this form. It's really, really simple. You can go to our website, voteradvocacy.org, and you can find that form and see samples on how to fill it out. It's really simple. And you fill out that form, you send it to the IRS, and it says to the IRS, listen, we want dollar-based limits. We don't like the activities-based test. We would like concrete dollar-based limits to measure our lobbying. And it's based on your expenditures as opposed to your activities, right? So you have concrete dollar-based limits. In addition to that, the definition of lobbying is you have a concrete, tangible definition of lobbying. So your organization can tell when it's lobbying, your organization knows when it's not lobbying, and if you think about it, that really helps you to kind of plan out your agenda for the year, plan out your advocacy in a real way. So you can set aside a certain amount of money that you want to spend on direct and grassroots lobbying, and you know when you're lobbying and you know when you're not. In addition to that, the penalty is much less severe. If you exceed your lobbying limit under the 501h expenditure test, you can only lose your tax-exempt status if you exceed that limit by 150% over a 4-year period. So you have a moving average over a 4-year period. Again, and you want to review that section on Schedule C of the Form 990, Part 3 of Schedule C on the Form 990. And again, that penalty is much less severe. So we encourage organizations to make the 501h election. So to review lobbying under the insubstantial part test, Lobbying is not defined. There's no clear definition, but what we know under that insubstantial part test is that contacting legislators to propose, support, or oppose legislation can be considered lobbying. Urging the public to contact legislators to propose, support, or oppose legislation is included in that nebulous definition. In addition to that, advocating for the adoption or rejection of legislation is considered lobbying. And again, if you have not made the 501H election, if after all I said today you decide, hey, we still don't want to make that election, well, what you need to do is you need to review the specific activities the IRS lists on Form 990, and whenever you engage in one of those activities, you need to be willing to account for that on the Form 990 to the IRS. So once you've made the 5H election, or if you have already made the 1H election, the question is, how do we measure that lobbying? How do we measure our lobbying, and how do we measure, or how do we get our lobbying limit? First step to that is to calculate your organization's exempt purpose expenditures. And for most organizations, this will include your annual expenses. This is equal to your annual expenditures, okay? So you want to calculate your annual expenditures. And for organizations with annual expenditures of $500,000 or less, your overall lobbying limit is 20%. So you can spend 20% of those expenditures on lobbying. Now, for most of us, that is a generous limit. And as your expenditures increase, $500,000 to $1 million, your overall lobbying limit is $100,000 plus 15% of the excess over that $500,000. And that number decreases, that lobbying limit decreases as your annual expenditures increase. So, for example, an organization that has over $17 million in annual expenditures is capped at $1 million. So the most you can spend on lobbying under the 501H election is $1 million. For most of us, we never get to that amount. But those are, again, quite generous. So those are some generous limits for most organizations. And I'll show you some examples of that as we move forward. Now, our grassroots lobbying limit, and a lot of tax practitioners like to joke about this, that Congress wanted to limit the amount of grassroots activity, the letters, the calls, the emails, so they limited your grassroots lobbying limit to 25% of our overall limit. So it's important to remember that. So we have to preserve and kind of maximize that grassroots lobbying limit as well. We'll talk about a way to kind of maximize the grassroots limit a little later on, but 25% of your overall limit can be spent on grassroots lobbying. So let me show you an example of C3s that have made the 501H election and how these limits work out. All right. And again, we encourage organizations to make the 501H election. If you have questions about it, feel free to contact us. So if you made for C3 that has made the 501H election, with annual expenditures of $250,000. Oh, let me go back. You can spend, again, 20% of the $250,000 on your overall lobbying, So that's $50,000. So if you'll see here in the orange on your screen, the orange here in the pie chart, that's your education, your non-lobbying advocacy, your research, meeting legislators, educating them on the issues, not necessarily lobbying. But all of the other activities that your organization engages in, that's not lobbying, right? And that's the bulk of what we do. But as you're planning out for the next year, and you're planning out your advocacy, and you see issues that arise that require you to to have a different form of advocacy, a more direct form of advocacy that reaches into the legislature or reaches into your city council and requires certain changes to happen, That's when the lobbying kicks in. And so you have an overall lobbying limit for an organization with annual expenditures of $250,000. Your overall lobbying limit is $50,000. So that's quite a bit, right? Now your grassroots lobbying limit is $12,500 because remember, it's 25% of that $50,000. It's 25% of your overall lobbying. So you could spend $12,500 of that $50,000 on lobbying, on grassroots lobbying. So if that's understood, let's move on to the definitions of lobbying. So this is the important part, I'm sure, for many of you to know when are we lobbying and when are we not? How do we know that we are, how do we know that we are lobbying, and how do we know when we're not lobbying? Well, first let's start off with the definition of direct lobbying. Direct lobbying is a communication to a legislator that expresses a view about specific legislation. And I'll repeat that. It's a communication to a legislator that expresses a view about specific legislation. So what's a communication? A communication is, fairly simple. It's a phone call. It's a tweet. Maybe a face-to-face meeting. A communication could also be a Facebook post. It could be a fax. Any form of communication that reaches directly to a legislator or reaches out directly to a legislator. And legislators are federal members of Congress. This definition also includes your state legislatures and your local legislative bodies. So your city council, your county board of supervisors, all of these bodies, these legislative bodies that pass binding legislation, are legislators under the definition, under the IRS definition of direct lobbying. Also, a bill, we ask the governor to please sign a bill, or we ask, for example, Kathleen Sebelius to get involved on issues around the Affordable Care Act when it was, for instance, still in Congress and it was moving. And if you ask the secretary to step into the legislative process, that would be asking her to become a legislator. And you would need to track and report that activity and your expenditures on that activity to the IRS, because that's lobbying. Okay? Also, appointment of judges. Oftentimes we, here at AFJ, it's a big part of what our justice programs works on. They work on ensuring that we have a fair judiciary, right? And so, working on the appointment of Supreme Court justices, those justices require the confirmation of the Senate. And so working on around those judges or trying to push for a person to be appointed to the Supreme Court, for example, or something that takes, or a position that takes confirmation of the Senate, that's lobbying. That would be considered lobbying as well, okay? Now, the special legislative rule is one of my favorite rules. This is the rule around ballot measures. As I stated before, earlier in the training, we talked about some avenues of advocacy, and we talked about ballot measure advocacy. Ballot measures, ballot initiatives, constitutional amendments, they're all growing in popularity. These ballot measures go to the people. The people, the general public, are considered legislators by the IRS, right? They are considered legislators because ultimately their vote determines whether or not these ballot measures will become binding legislation or become law. So we have to keep that in mind. And when you issue petitions, for example, to start a ballot measure or to get a constitutional amendment on the ballot, whether it's referenda or a bond measure or something to that effect, that is lobbying. You would need to track and track your time, track your expenditures, track the staff time, and the overhead associated with that, to to the IRS, okay? So remember that ballot measures are considered lobbying, or a ballot measure activity is considered lobbying by the IRS, okay? Now, who's a legislator? Who doesn't count as a legislator? Well, so special purpose boards, school boards, planning commissions, zoning commissions, water boards, water commissions, and the like, these groups usually enforce or they pass recommendations. School boards, for example, work on, or sometimes make recommendations on curriculums or, some of the activities that the schools engage in or the policies of the school. They aren't considered legislators by the IRS. Those are special purpose boards. They don't pass what we consider binding legislation, or they don't necessarily have a legislative agenda. Sometimes they make recommendations to a legislature, but they are not considered legislators. So again, great way to expand your lobbying limit is to engage in advocacy with these special purpose boards or these commissions, which again hold a lot of power, and we can do some advocacy around these issues, but they are not considered legislators under the IRS definition. Specific legislation. So what's specific legislation? So we've gone through the elements of direct lobbying. We've gone through that definition. So we've got a communication to a legislator that expresses a view about specific legislation. So what is specific legislation? Well, of course, it's anything with a bill number, right? That's simple enough. Anything with a bill number. Budgets are considered special or specific legislation by the IRS. Usually the executive, whether it's a governor or a mayor or the president, will put together a budget or propose a budget, and then Congress or your state legislature then has to approve that budget in most instances, in most states or most cities. So, it's important to remember our work on budgets, whether we're trying to get something in the budget, Medicare or Medicaid, funds for, disabled veterans or disabled Pennsylvanians, certain funding and certain help for those individuals, that is lobbying. That is considered lobbying. So you need to track your time, you would need to track your expenditures on those issues. And we'll talk about tracking and reporting briefly, too, at the end of this presentation. So you know how to track and you know how to report your expenditures to the IRS. And then we've got our idea man here. That's what I call him. The light bulb goes off. There are times when, the light bulb goes off and you say, listen, I've got a really great idea. I want to talk to my legislator about it. Is that lobbying? Well, depends, right? It depends on how specific you are. Model legislation or legislation that you pulled, for example, from another state. So most of you are in Pennsylvania. If you, for instance, pull a bill, that you find a bill in New York, and you say, hey, listen, I'd like to see this bill introduced here. Well, when you go to your legislator and you communicate that desire to have that bill introduced and you've got the bill in hand, that's lobbying, okay? That's specific legislation. Now, if you just go with an idea, and you want to discuss an idea, or you want to discuss, concepts and principles, that's not lobbying. That's not specific enough. So it goes to the specificity of the communication, or the discussion, or the legislation, or the idea that you are putting out there. Okay? The more likely than not that it's lobbying. So what's not legislation? Again, these are great ways to expand your lobbying limit and to avoid surpassing that limit or reaching that limit. Is to engage in advocacy around regulations, around executive orders, to engage in advocacy around the enforcement of laws that are already on the books, that are already being enforced, and you want to change, for example, the enforcement of those existing laws. I'll show you some examples of this a little later, but these are great ways to expand your lobbying limit. In addition to that, litigation, right? Bringing suits is sometimes a way that we can engage in advocacy. That's very effective. Grassroots lobbying. So many people talk about grassroots lobbying. This is another powerful form of advocacy, a powerful form of lobbying. Grassroots lobbying is defined as a communication to the general public that expresses a view about specific legislation and has a call to action. Now, a call to action is very narrowly defined by the IRS. There are 4 methods that we can use to engage in a call to action. Okay. Now, the first way is to tell the general public to contact their legislator. Second, we can provide contact information for a legislator or for a number of legislators. Third, providing a mechanism. So sometimes you'll go to a website, it will, basically have a letter written for you. You type in your name and your address and you press send and it goes to your legislator. Well, if you've done that on your website, you are providing a mechanism to engage in grassroots lobbying, okay? So providing a mechanism is another form of call to action. Finally, we have identifying legislators, or what's referred to sometimes as an indirect call to action. These are the 4 methods that we can use to engage the general public in a call to action, okay? So again, it's very narrowly defined. If there is no call to action, there's no call to action there, it's not grassroots lobbying. So let me show you some examples of call to action. Here's one. Action alert, the DREAM Act. Call Congress to pass the DREAM Act and tune in for the vote. So this was an action on MalDef's website. And as you see above, it says call Congress, telling the general public to call Congress. In addition to that, we've given their contact information in this second call to action. And it gives their phone numbers, right? So that's a call to action, expressing a view about a specific bill, the DREAM Act. It's a communication going to the general public. That is grassroots lobbying, okay? Here's a second call to action. So we've listed the members of the Appropriations Committee, given their contact information, and so this is another form of the call to action. We're expressing a view, again, about a specific legislation, expressing that to the general public, and we're asking the general public to reach out to their legislator as a call to action. Here's the mechanism that we talked about. Providing a mechanism. This is the third narrowly defined call to action, where we on our website, give the general public a mechanism to reach out to their legislators and express their opinion in their opposition to a specific piece of legislation. It's got a call to action there. It's a communication to the general public and expresses a view about specific legislation. That's a call to action. Now, I want to point out again that your grassroots lobbying limit, remember, we talked about this earlier, your grassroots lobbying limit is a quarter of your overall lobbying limit. So it's much smaller than your overall lobbying limit, or what you can spend on lobbying generally. So it's a quarter of that amount, okay? So it's much smaller. So we want to expand that grassroots lobbying limit and only use it when it's absolutely necessary, right? Because we can spend less on that. We don't want to surpass our lobbying limit. So we want to stay within those limits. So we'll talk about ways to do that later. And here's the fourth form of a call to action, the indirect call to action. We just, list legislators. Sometimes we refer to this as, arm twisting. There may be a few legislators who can't decide on a vote, and we want to push them in a certain direction, so we're asking the general public to contact a specific number of individuals, a specific number of legislators. And so we list those legislators and ask the general public to contact them and communicate with them and express their view on a legislation or a nomination that requires the confirmation of Senate. How do we maximize the limits that we have? So, as C3s, we have these limits on our lobbying, but, there are ways to engage and to maximize those limits. So here's the first way. We can leave off a call to action on something that would otherwise be grassroots lobbying. So remember I mentioned before that if there's no action, it's not grassroots lobbying. And a call to action is very narrowly defined by the IRS. It's a very narrow definition. There are only 4 ways to do it. Action. The numbers of the House and Senate, actually we have 3 calls to action here. You've got tell the legislature, also call the main legislature, and then finally listing the contact information. So 3 forms of a call to action. So this is a grassroots communication. So we're talking about how to expand our grassroots lobbying limit, which is, again, a quarter of our overall lobbying limit. So how do we do that? Well, one way we can do that is by leaving off the call to action. So as you see here, I've removed that call to action. I've taken out, the numbers of the houses, the legislature. I've taken out call your legislature. And all we've got here is an issue ad, right? Issue advocacy or public service announcement. It says the more these cost, the less they'll smoke. It's essentially the same message, raise the cigarette tax without telling the general public to reach out to the legislator over a specific piece of legislation, okay? So these are, again, ways to maximize our lobbying limit. So even though we're limited, there are things we can do to maximize the limit and still engage in advocacy. One of these ways is to engage in administrative advocacy. So going to different agencies and trying to change regulations or submitting comments to change rules or regulations, enforcement of existing law is a great way to engage in administrative advocacy, right? Changing the way laws are enforced, changing the way the police enforce, for example, the Safe Communities initiative of ICE. That's a great way to engage in administrative advocacy, if you will. And asking, a governor or mayor, the president to sign an executive order, that's not lobbying, right? So you wouldn't have to count that against your lobbying limit. It wouldn't go towards your grassroots lobbying limit or your direct lobbying or your overall lobbying limit. It's a great advocacy tool and way to preserve your lobbying limit. And then here we have litigation, another good form of advocacy. Another way to engage in advocacy. Filing amicus briefs, for example, is legislative or legal advocacy. Excuse me. So our lobbying exceptions, and these are important to remember. There are exceptions to the lobbying definition, whether it's nonpartisan analysis and research, requests for technical assistance, self-defense, and examinations and discussions of broad social, economic, or similar problems. So, nonpartisan analysis. So this requires a full and fair discussion of the facts. You have to talk about both sides of an issue, pros, cons, and then you want to make sure to broadly disseminate the publication that you put together. If we do that, then you can express view about specific legislation. You can include an indirect call to action. And there are also rules around using that publication in a subsequent grassroots lobbying communication. If you want to know more about those rules, feel free to call us. But this is a way around, the lobbying definition, a way to expand our lobbying limit. Technical assistance is also a heavily used widely used exception to the lobbying definition. So if you're invited in writing on behalf of a committee in your legislature to testify, as long as you make your testimony available to every member of that committee, and you can even ask for a member of the committee to invite you in writing, then you can take a view or express a view on specific legislation. This is called technical assistance, and it does not count as lobbying. It's an exception to the lobbying definition. Self-defense is not used much, but if issue related to powers and duties, related to our tax-exempt status, related to the deductibility of contributions, we can then lobby on that issue and it not count against our lobbying limit. But very rarely is this exception used. And finally, blue ribbon reports, annual reports, things of that nature are also exceptions to the lobbying definition. And record keeping, in order to display to the IRS and show them that we are indeed, and record keeping, in order to display to the IRS and show them that we are indeed lobbying and doing everything above board. And we have to report what we spend on lobbying to the IRS. And so in order to do that, we need to have good record keeping. It's a great management tool. It's a great way to lobby without fear of exceeding your limits. It demonstrates to foundations and to funders that we are indeed, on top of our finances. And so record keeping is really important. So how do we keep track of our costs? We've talked about the lobbying limits for C3s. How do we keep track of that? Well, if you've made the 501H election, remember, what we're tracking is the cost, your expenditures, remember? This is expenditure based. So you want to track your direct costs, staff time, and your overhead, a reasonable allocation of those amounts to report on the Form 990. Remember, Schedule C of your Form 990. If you're under the insubstantial test, remember that test that looks at your overall activity, that default test. We're looking at volunteer activity. You're looking at donated goods or services and activities specifically listed on the Form 990. Now remember, under the 501H election, it's only expenditures, right? So volunteer activity, there's no staff time or staff cost associated with that volunteer activity. So you can have volunteers working on things, whereas with the insubstantial part test, if you have volunteers engaged on certain lobbying campaigns, then you would need to report that volunteer activity to the IRS. Okay, another advantage of the 501H election. And under the 501H election, we're looking at reasonable allocation of direct costs. So this is money you might spend on a cab ride to the Capitol, or for photocopies, etc. Staff times. So we use a timesheet, and I'm sure many organizations, you probably use a timesheet as well to keep up with the direct lobbying or the grassroots lobbying for certain employees. And then at the end of the month, you tally that amount. And so, for example, for an executive director that spends 100 hours working, right, in a month, let's say 100 hours. What you want to do is say 15 of those hours are on rec lobbying, 5 hours on grassroots lobbying. And remember, we want a reasonable allocation. So we're getting the percentage, 15% was spent on direct lobbying, multiply that times the compensation per month, and then you get the total amount attributable to direct lobbying. And here's an example for the grassroots lobbying. 5% times 5,000 the compensation per month, and that will give you $250. And then overhead, finally. How do we get our overhead percentage? Well, overhead will include your rent and your insurance, the telephone bill, and things of that nature. So $15,000 spent on overhead per month. how we get our percentage to report to the IRS, the amount to report. We take $15,000, which is our overhead cost per month. 10% times $15,000, $1,500 for your direct, $750 for grassroots. And then what we do is we take those amounts for direct and grassroots lobbying, direct costs, staff time, overhead, and we add all of those expenditures together and we get our total lobbying expenditures for that month. And we do that, over a year period, and we report the final amount to the IRS, and we want to keep that below our lobbying limit. So we do have one question. Are 501c3 volunteers considered direct lobbying? Only if, so the issue with volunteers and C3s, right? If you have volunteers engaged in activity that is defined as direct lobbying. Remember what we talked about earlier. Direct lobbying is a communication to a legislator that expresses a view about specific legislation. If your volunteer is engaged in that activity, they are helping to prepare for a direct lobbying meeting. They are helping to prepare for a grassroots lobbying action. They actually engage in lobbying under those definitions. Then that's lobbying, and you would need to under the 501H election track the expenditure for that, right? So there's no staff time expenditure because they're not being paid. But there may be a direct cost, associated with producing, maybe a fact sheet or something. There may be some overhead associated with it, but there's no staff time cost, right? Under the insubstantial part test, however, that volunteer activity that goes, that takes place in the lobbying context has to be reported. And that's one of the activities listed on the Form 990 for those who are under that default insubstantial part test. Okay? So sometimes it can be, you have to report the cost regardless. If there's no cost to report, then you're not reporting a cost. If there is a cost, if there's no cost to report because you're under the insubstantial part test, then you need to report that volunteer activity. Okay? If there are any more questions, again, I'll give you, feel free to type them into the chat box. We are about finished, and here's our last slide, our contact information, which is, I think, very important for many of you and for any organization. If you want to reach out to us, feel free to call at any time. You can call us at 866-675-6229, or you can reach us by email. We have an attorney on call every day to take these types of questions, whether it's lobbying, election law, foundations, and the like. We're here to serve you. You can go to our website. We have fact sheets, publications on all of these issues and many more, blog posts and so forth too. And so we have a West Coast office. If you know anyone on the West Coast or are affiliated on the West Coast, we also have a West Coast office in addition to our office here